Dr. Sudarshan Nachiyappan, Judge Dalveer Bhandari, Judge Peter Tamka, Judge Abdul Qavi Ahmad Yusuf, Shri Narendra Singh, Professor Jambolkar, Honorable Justices, Excellencies, students, distinguished guests, ladies and gentlemen. I deem it an honor to be invited by the Indian Society of International Law to address the World Congress on International Law. This distinguished galaxy of justices, judges of the International Court, legal scholars, and lawyers constitute a formidable and learned audience. The relevance of international law in today's rapidly changing world and the new challenges we have to collectively address is a good subject for serious cogitation. International law, as it is now understood and practiced, is of relatively recent origin. It owes its origin primarily to the Westphalian world order, forged in Europe in the 17th century. Its beginnings, modest and limited, coincide with the rise of nation-states in Europe, bore its stamp, and focused on common values and the reciprocity of interests. The principles of sovereignty and legal equality of states were first enunciated by the Dutch jurist Hugo Grotius in the year 1625. The principles of sanctity of agreements entered into, as also the saving conditionality allowing non-compliance, lent balance to the commitments entered into by the nation-states. The two world wars presented fresh challenges to the principles and practices of international law. These related to the rectification of boundaries, care of refugees, administration of the territory of the defeated states. Efforts to address these and related issues through the creation of the League of Nations were unsuccessful. This failure and the horrors of World War II led to the appreciation of the necessity of international cooperation and the formation of the United Nations as a body capable of ensuring obedience to international law and maintaining peace. The preamble of the UN Charter asserts this as one of the objectives, and I quote, "to establish conditions under which justice and respect for obligations arising from treaties and other sources of international law can be maintained," end of quote. The period since 1945 has been highly productive in regard to the growth and evolution of international law. International cooperation was widely accepted, though not universally. The first few decades in particular gave cause for optimism. The United Nations assisted the process of decolonization and the effort to end apartheid. The UN multilateral system contributed to the enunciation of normative principles to regulate international conduct. Questions such as disarmament, social development, gender equality, population, food and water, and a host of problems relevant for the developing world were addressed. Common transnational services related to civil aviation, maritime regulation, health, telecommunications, postal systems, refugees, world weather, and food security were put in place. 193 nations are now members of the United Nations and subscribe to its charter. The ambit of the rules of international law has widened and includes intergovernmental organizations, corporations, non-governmental organizations, as well as individuals. The founding fathers of the Indian Constitution accepted these broad principles and incorporated them in the directive principles of state policy. Pursuant to this, the state shall foster respect for international law and treaty obligations of organized people with one another. Ladies and gentlemen, the United Nations has its limitations. It is a voluntary association of sovereign nation states. These states have their own aspirations and had sought the membership of the United Nations in their perceived self-interest. For this reason, some parts of international law remain highly contested. These relate to the laws of warfare, to the concept of state sovereignty, and to a full range of self-serving interests of the powerful who wish to use international law to further their political, economic, and security interests. A case in point is the Charter of the International Court of Justice and its optional clause. Within the ambit of public international law, institutions and organizations have been used to impose unequal treaties and evolve concepts that have encouraged curtailment of sovereignty, like the right to protect, seek intrusive presence within sovereign states, like peacekeeping and peace building. Conflicts of law in civil law jurisdictions, which constitute private international law, seek to address disputes between business corporations outside a unified legal framework. This has led to increasing use of commercial arbitration under the New York Convention of 1958. There is also the growing application of supranational law to address global commons and such international issues relating to new technologies, evolutions in genetic sciences, and problems presented by pandemics and catastrophic disaster events. Globalization has not only increased the importance of international law, but also the complexity of international legal issues. International law has grown to encompass a wide variety of fields, including the prohibition of the use of force, human rights, protection of individuals during war and armed conflicts, fight against terrorism, trafficking in drugs and other serious crimes, environment, trade and development, telecommunications and transport. The power structure of the organization created in 1945 clearly reflected the power realities of the world after the Second World War. It was dominated by the victors of the Second World War who fashioned its modalities to further and facilitate the pursuit of power in political and economic terms. Much has changed in the world since then, but the underlying realities of the power lesson remain true. If anything, the intervening years have eroded the effectiveness of the United Nations and its institutions, and the need for reform has never been more urgent. The world has changed, new power realities have emerged, several new regional and trans-regional groupings have come into being, but the United Nations remains largely unaltered. The need for reforms is widely recognized, and several halting efforts have been made to change methods of work, procedures, financing arrangements, delivery mechanisms, and accountability criteria, but the outcomes have been less than satisfactory. What is required is structural and systemic reforms that has still to happen. There is a growing perception that there has been a decline in multilateralism. Developed countries have begun to look upon the United Nations and its functioning in terms of their own priorities and objectives. The UN's Charter functions in the areas of money, finance, trade, expenditure, indebtedness, and developmental strategies have been transferred to the IMF, the World Bank, and the WTO. In these bodies, the major economic powers, because of their voting power or power of retaliation, as in WTO, have come to dominate the decision-making in these vital areas. In the area of development, the focus is on the economic and social problems of developing countries and their internal governance issues. Here too, in the name of globalization, the thrust is on the open market, foreign investment, lowering tariffs, and reducing the role of the state. The UN's method of functioning has also changed from being a negotiating forum on hard economic issues where substantive, legally binding commitments were undertaken. It has increasingly become a forum for an exchange of views and where experts are invited to conduct dialogues and analyze global economic and social trends. Another important and in some ways a game-changing development relates to the funding of the United Nations. The UN finds itself starved of adequate and predictable funding. Dues have been withheld, budgetary restrictions have been imposed, and assessed contributions today account for a small percentage of the total expenditure of the United Nations. The proportion of voluntary funding has grown dramatically and today provides a high percentage of the total. This feature has been effectively used by the major powers to impose their own priorities on the UN by dominating its budgeting, accounting, and administrative apparatus. This has resulted in the dilution of the UN's regulatory and norm-setting activities. Excellencies, ladies and gentlemen, although international laws and the institutions created to further its influence and application have grown significantly over the last 6 decades, international law is at a crossroad and needs new direction. Its ambit has grown from interstate relations to individual rights and now covers civil society and corporations apart from state conduct. It extends to the global commons and attempts to address new challenges being posed by new technologies, non-state actors, unhindered information, and financial flows. While it is trying to cope with the transnational concerns relating to pandemics, narcotics, illegal trafficking in human beings and arms, it cannot escape addressing some fundamental issues. A few of these need to be mentioned here. 1. The nature of the state is being called into question. Today, several parts of the world are engulfed by crises of identity, political control, and stability. The nation-state system is under strain, prompted by geopolitical, short-term strategic compulsions and radicalized non-state actors. Colonial geographies have begun to dismantle. Military interventions in established nation-states have led to instability and to the growth of sectarian and ethnic discords. Non-state actors of different ideological persuasions have violated borders and sovereignty at will. Some of these transgressions have received support from other powers and nation states. 2. There is a contradiction at the heart of globalization. The international economic system is becoming global, while the political structures of the world is still based on the nation state. Goods and capital seeks to flow unhindered across national boundaries. Individual nation states resist global pressures in seeking to protect their national interests. Economic globalization in its essence, as Henry Kissinger has put it, ignores national frontiers. International policy emphasizes the importance of frontiers even as it seeks to reconcile conflicting national aims, end of quote. Thirdly, values and state structures, Western in origin and proclaimed as having universal validity, are increasingly being questioned. Concepts such as democracy, human rights, and international law are subject to divergent interpretations. In the absence of a consensus and a mechanism for enforcement, international law is increasingly proving ineffective. Fourthly, the logical consequence of the promotion of democracy as, as a universal value necessitates its induction in the governing structures of the international system. A theory of legitimate power, in the words of the political scientist David Held, is increasingly a theory of democracy in the interlocking processes and structures of the global system. Reforms aimed at bringing this about are essential to rejuvenate confidence in the international system, accommodate the polarities, and induce movement towards a more stable world order. Here, then, is the challenge to international law and organizations that are responsible for its implementation. I thank the Indian Society of International Law and Dr. Nachappan for inviting me today, and I wish this conference success in its deliberations. Jai Hind.